This is Lesson 8, Chapter 11, Contracts for Real Estate Transactions. And we're moving to page 2, question 44. And the answer, which of the following statements about the criminal offense of misleading advertising in Section 42 of the Competition Act is false? And the answer is 3. A representation to the public includes print and digital representations, but not oral representations. And that's completely false. You know what? The Competition Act, Section 52, it includes oral representations. Now, these other things are true. 1, the offense involves the making of a representation to the public that is false or misleading in a material respect for the purpose of promoting any business interest. 2, to escape liability, one must show that he or she honestly believed that the representations were not false or misleading and that exercised due diligence in making sure that was the case. And 4 is correct too, where the requirement that the representation be false in a material respect refers to whether the representation would have had a real effect on an ordinary consumer's buying decision. So those things are all true, but the one that's false is 3. A representation to the public includes print and digital representation, but not oral representations. That is bullpucky. Question 61. The Law and Equity Act contains a provision that is often referred to as the requirement of writing. Which of the following accurately summarizes the requirement of writing contained in Section 59 of the Law and Equity Act? And the answer is, drumroll please, number 4. None of the above 3 statements accurately summarizes the requirement of writing. So, number 1, a contract respecting land must be in writing or it is void. No. 2, a contract respecting land can never be enforced against a party who has not signed it. No. And 3, a contract for the sale of land must be contained in one written document. No. So none of these 3 statements are accurately summarize the requirement of writing. So the answer is 4. Question 93. An amendment to a contract of purchase and sale is, number 1, not legally binding on the seller and buyer until finalized in writing and signed by all parties to the original contract. So if you want to amend a contract of purchase and sale, that is not going to be legally binding on the seller and buyer until it's finalized in writing and signed by the seller and the buyer. Okay, from the original contract. Question 113, a contract of purchase and sale is, number 3, a binding contract if properly drafted. So get that. A contract of purchase and sale is, number 3, a binding contract if it's properly drafted. Now, we're on to page 3. Which of the following is not required in a contract of purchase and sale? And so the answer is 4. The rate of commission payable. So that is not needing to be mentioned in the contract of purchase and sale. The rate of commission payable. But all these other things are required. 1, the names of the parties. 2, a description of the property being sold. And 3, the purchase price. But not, number 4, the rate of commission payable. So number 4 is the true answer. Question 153. Larry and Teresa orally agree that Teresa will lease 100 acres of farmland owned by Larry for 5 years. As part of the agreement, Larry agrees to build a barn, which he does at a cost to him of $10,000. Which of the following statements is true? 3, the lease agreement may be enforceable by Larry because he has altered his position by spending $10,000 on a new barn in reliance on the lease. So let me back up again. Larry and Teresa orally agree, all right? There's no written contract yet, but they orally agree that Teresa will lease 10 acres of farmland owned by Larry for 5 years. As part of the agreement, Larry agrees to build a barn, which he does at a cost to him of 10,000 schmackaroonies. Which of the following statements is true? And number 3, the lease agreement may be enforceable by Larry. Why? Because he's altered his position by spending $10,000 on a new barn in reliance on his lease with Teresa. Question 187, which of the following statements is correct? And the answer is 4. Contracts of purchase and sale can be assigned as long as the rights of the other party are not prejudiced. Let me read that again. The answer is number 4. This is correct. Contracts of purchase and sale can be assigned as long as the rights of the other party are not prejudiced. True. Question 225, and we're going to page 4. Section 59 of the Law and Equity Act of BC is intended to prevent frauds from occurring in respect of the disposition of land. Section 59 provides that, and the answer for 225 is number 2. Only D is true. So what is this D which is so true? Mentioned in answer number 2, which is correct. So D is where a person acts to his or her detriment in reliance on an oral contract respecting land, a court will enforce the contract if it would be inequitable not to do so. Okay. Where a person acts to his or her detriment in reliance on an oral contract respecting land, a court will enforce the contract if it would be inequitable not to do so. And that is answer 2, only D is true. That is Section 59 of the Law and Equity Act of BC. Question 284, which of the following statements is false regarding successful negotiations? And the answer to 284 is number 4. This is false. Practice through trial and error is the best way to internalize learned negotiation skills. Well, that's false. Practice through trial and error is not the best way to internalize learned negotiation skills. Really? Really? So it's number 4. So the other ones are true. 1, honed negotiation skills are essential for handling all aspects of a client's real estate transaction. 2, learned negotiation skills can be used in one's personal and professional life. And 3, reading about negotiating skills is not sufficient to master the skills, as practice is required as well. Those things are all true, but this thing is false. Number 4, practice through trial and error is the best way to internalize learned negotiation skills. Really now? 340, which of the following statements is false? And the answer is 2. Unless a deposit is paid when an offer to purchase is made, there is not a binding contract for purchase and sale. Unless a deposit is paid when an offer to purchase is made, there's not a binding contract for purchase and sale. No, we don't need necessarily to have the deposit to make the contract binding. But these other things are true. So 2 is false, and that is my answer. But let's take a look at 1, which is true. A deposit is held by the brokerage as a stakeholder until the real estate transaction is completed. Yes. 3, if a deposit is made by uncertified check, the brokerage should only issue a check on its trust account when the brokerage knows that the deposit check has been honored. Yes. And 4, once an offer has been accepted, the brokerage may only return the deposit if it has the seller's written permission, and that's also true. But we are looking for false statement, and that was and that was where am I here? Yeah, that was number 2. Unless a deposit is paid when an offer to purchase is made, there is not a binding contract for the purchase and sale. That is false, and that is why we choose it. And we go on to page 5, question 351. Which of the following is not generally required to create an enforceable contract of purchase and sale? And the answer for 341 is 3. The completed statements of adjustment. We don't need that, generally speaking, to create an enforceable contract of purchase and sale. So the number 3, the completed statements of adjustment, not generally needed to create an enforceable contract of purchase and sale. Question 363, when completing a listing contract, a licensee should, number 3, independently check information with the appropriate authority where possible. So when completing a listing contract, a licensee should, number 3, independently check info with the appropriate authority where possible. Example of this is to check with the online land title office to do a title search. That is an example of independently checking information. So we've got 375, where a condition precedent is inserted in a contract of purchase and sale, a licensee might also include a time clause. All right? Which of the following definitions accurately describes such a clause? And so we go to 3. The clause permits the seller to require the removal of the condition precedent within a specified time if a better offer is received. So let's move back again. The answer is 3. The clause permits the seller to require the removal of the condition precedent within a specified time if a better offer is received. And that is the following definition that accurately describes a time clause. We move on to page 6. In page 6, 389, where a buyer under a standard contract of purchase and sale refuses to perform, the seller will not have the following remedy. And we go to, just wait a second. Let me see if I am in the right way here. Yeah. Anyways, so we got page 6, 389. Where a buyer under a standard contract of purchase and sale refuses to perform, the seller will not have the following remedy. And 389, answer is 4. A forfeiture of a deposit representing 50% of the purchase price as liquidated damages. This is not a remedy. Number 4, the forfeiture of a deposit representing 50% of the purchase price as liquidated damages. No, it's not possible. It's not a remedy. But number 1, specific performance is. 2, damages for loss of bargain is also possible. And also 3, damages related to the costs of preparing necessary documents. But for the forfeiture of a deposit, 50% of the purchase price as liquidated damages, no. All right, so that's our answer. 412. A seller refuses to sign a subject removal form to strike out a condition precedent from a contract of purchase and sale. Assuming that the condition was made exclusively for the benefit of the buyer, the agreement is 412. Number 1, binding. Let me read it again. The seller refuses to sign a subject removal form to strike out a condition precedent from, that is a subject clause, from a contract of purchase and sale, assuming that the condition was made exclusively for the benefit of the buyer. The agreement is, number 1, binding. 444. Vilma has just accepted Patricia's written offer to purchase Velma's home, which contains the following clause. This offer is subject to the buyer selling her home at such and such an address by December 31st. Which one of the following statements is true for 444? And the answer is 4. This requirement may be waived by Patricia on or before December 31st. So we've got a situation, we've got Patricia, she's written an offer to buy Velma's home Vilma's received that in her hot little hands, but there is a clause. And this clause is, this offer subject to the buyer selling your home, the buyer is Patricia, selling her home at whatever address by December 31st. So the answer to 444 is 4. This requirement may be waived by Patricia on or before December the 31st. So much power in somebody's hands. Page 7. 286. A subject to clause in a contract of purchase and sale is correctly known as 286. What? 286. Okay, 286 is not on my list. Okay, where? Just wait a second. We're getting out of order here. We went from 444, and now we're going to 286. How is that possible? But this is a mistake on page 7. But whatever, I will try to answer it. The subject to clause in a contract of purchase sales correctly known as a number 1 condition precedent. Okay, that was my mistake, but whatever. I'm supposed to be doing 454. And now let me check out. I don't even have 454. So I will circle it, 454, and I will see if I can bring it to you by the end. How about that? Good deal? Question 463, it's on my list. Oh, shit. You know what? I didn't do all these things. They're all... Okay, you know what? There's a whole whack of these which I didn't do. Okay. Just squeeze me 1 second. I have a whole bunch of these which I have not done. And I will do it. Okay? I promise you. I promise you. Okay? You got that? So we are back in business when we reach 369. All right? No. 5. Okay. Blah, 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 blah. I'm totally screwing things up now. All right, we got to 444. Yes. And as soon as we got to 444, things took a dark plunge into the mistaken realm of my brain. And so after 444, as far as I know, I screwed up. So this page, yeah, it's a wipeout. But let's go to 360s. These things are not even part of it. Okay. All right. I think I'm going to repair this at the end. But anyways, let's go to 4. Okay. You know what? All of these are wrong. So I need to stop now and I will continue later on. Okay? How about that? Satisfied?